Well, let me see if I can welcome everyone. Welcome to our third annual AI panel discussion on the benefits and risks of using AI in your legal departments. I'd like to thank our host, Bobby Ghajar, with his team here at Cooley for providing us the space, as well as our libations later. My name is Tram Pham, and I'm the managing director at San Francisco's in-house recruiting group. This is third year now. I think the first year we did webinar, and then the last two have been in person. And yeah, we think about maybe taking this as a roadshow. I'd like to. I have been practicing, well, I started practicing at as a global project finance associate at Milbank Tweed in New York, and then went in-house to a couple of design firms before finding my love of recruiting. So here we are in my 13th year of recruiting. I am a graduate of Stanford University and Columbia Law School. I'd like to introduce to you our esteemed panelists. Bobby is an intellectual property partner at Cooley, based in SoCal offices. His practice is primarily focused on advising companies in trademark, trade dress, copyright, right of publicity, and false advertising litigation. He has handled dozens of high-stakes litigation and appellate matters for global brands, celebrities, and unicorn companies. Many of his cases have helped to shape and create legal precedent, including those specifically related to AI in recent years. Bobby is a graduate of UCLA and Southwestern Law School. Rashmi is a senior vice president and chief legal officer at Informatica, where she leads the company's global legal and compliance teams and is also a member of the executive committee. She brings more than 2 decades of experience advising high-growth technology companies through rapid expansion, complex transactions, and strategic transformation. Prior to joining Informatica, Rashmi led the legal functions at Sophos, Tram Phi, Bloomreach, Marin Software, and VMware. Where have you not been a general counsel? She took Marin Software through its IPO. She began her career as a software engineer at Rome Systems and Apple before transitioning to law. Rashmi holds a BA in computer science and a JD from the University of California, Berkeley. Tram Phi leads the legal compliance and public affairs functions at Databricks, bringing decades of legal, regulatory, and public policy experience to the leadership team. Prior to Databricks, Tram served on a variety of executive roles, most recently as Senior Vice President, General Counsel, and Secretary at DocuSign, and prior to that, as Chief Legal Officer and Chief of Staff at Imperva, Inc. Tram also served as Vice President, General Counsel, and Secretary at ArcSight until its acquisition by Hewlett-Packard, and then as General Counsel of HP Software Security. Earlier in her career, Tram served as the Senior Legal Executive at InVision Technologies. She received her BA from San Jose State University and JD from the University of California, Berkeley. To get an overview of the current legal and regulatory landscape around issues on the creation and use of AI, I always ask Bobby to give us a short tutorial on what's happening on the litigation front and the things we should be looking out for. And I always give him 10 minutes and no more.
10 minutes to do an hour presentation. Thank you. Good afternoon, everybody. Welcome to Cooley. My name is Bobby Ghajar. We're going to run through some of the legal issues that we're seeing, and this is going to be at a really high level. I'm going to focus on some of the biggest cases you may be reading about, and then I'm going to conclude with the last few minutes to talk about the misuse of AI by lawyers in litigation. And so if you've read any article about somebody submitting a brief with a made-up case, well, buckle in. You're going to hear about how poorly some attorneys are faring, and attorneys are not learning their lesson. A brief disclaimer. Okay, so let's talk about AI litigation. 2.5 years ago, there would be one pin. It would be on the left. It would be here in San Francisco. These are all of the pending generative AI litigation cases. For the most part, these are copyright cases. Many of them are class action cases. What will strike you is that it is truly bi-coastal. The largest concentration is here in the Bay Area. A number of the cases were then consolidated in New York. You'll see the cluster on the right-hand side. There are a handful in Delaware, a couple in Boston, and newly filed cases in Los Angeles, which we'll talk about. I thought this was a really interesting infographic from Axios. If you can read it, and I can supply you with slides afterwards, it talks about the different lawsuits against the major AI companies and the deals that have been reported that these companies have struck with publishers. And there's a bit of tension because the position in the litigation, which we'll talk about in a moment, is it is fair use to train off of publicly available data. And so to the extent that data is public, there is no need for a license. And so nonetheless, you are seeing major companies strike licensing deals. Now, some of them have been in the news space, and there are reasons to do so beyond getting data. It's to give your users real-time access to current events and news, to images, to improve image-based models, and so on. So I thought this was a neat graphic. It came out just last week. If you imagine the world in 2022, there would have been one or two cases filed in the Gen AI space. We've chronicled them. The cases picked up in 2023 and 2024. So you'll see some of the early cases in 2022. OpenAI was sued in 2023. There was what I call a copycat case against Meta, and then more copycat cases. You'll see that on the top left, the Cadre v. Meta, and so on. And then different entities were brought into the fold. Google was sued mid-2023. Anthropic was sued late 2023. And the list goes on. So this slide represents 2024 on the left, 2025 lawsuits on the right. What sticks out are new defendants on the left, including NVIDIA, Suno, and others, Perplexity, and then Chegg v. Google was a different type of case. Chegg was a sole plaintiff against Google, and then Midjourney was sued by Disney, and then Warner Brothers. Microsoft was sued again, and then most recently, last week, Apple was sued. Apple had stayed above the fray until very, very recently. So that's the landscape in terms of where the cases are filed and what cases were filed. Let me give you a very high-level overview of what these cases are about. At their core, they're attacks on the unauthorized use of copyrighted works to train AI models. There are allegations in many of the cases, certainly the early ones, that because the AI models trained on copyrighted works, whatever comes out of them must be derivative of the copyrighted works. So this argument was the models themselves are derivative works. That didn't really work. Then there are cases in which plaintiffs allege that what the models spit out, the output, is substantially similar to what's been input. And so there have been a few cases that have been able to highlight the ability of a tool to regurgitate a news article, for example. There's a case against Anthropic over music lyrics, Perplexity over news, OpenAI over news, and Midjourney over images of alleged characters. So those are few and far between, but there are a handful of them. Another common theme that we see making a resurgence is that when data is cleaned or data is fed into the AI for training purposes, a lot of the engineers will strip information to avoid redundancy, to avoid the model overtraining on words that are insignificant. So as one example, a lot of companies are stripping copyright notices, table of contents, and it's not for any nefarious purpose. It's just for the purpose of training, not for the purpose of hiding anything. Nonetheless, some plaintiffs have made a story out of this and said you're violating the DMCA by stripping CMI. Finally, there are allegations of contributory and vicarious copyright infringement. You're creating a model that's able to do certain things. You should be liable for the conduct of your users. And in most, if not all of these cases, the defense at the center of the litigation is fair use. And so we've seen fair use play out in a couple of cases. And I'm going to highlight two given our short time together. Cadre v. Meta and Bartz v. Anthropic. These are, you could call them companion cases decided by two different judges around the same time in the Northern District. The difference between the two cases is that in the Cadre v. Meta case, discovery closed. There was an orderly summary judgment motion on the issue of fair use. In Bartz v. Anthropic, the judge, Judge Alsop, invited briefing on class certification and summary judgment in the middle of discovery. So imagine the parties had to brief summary judgment while depositions were still occurring. So we have different judges hearing each case, slightly different timelines, different attorneys, similar to cases against the other Gen AI companies. And you had two important orders. Judge Alsop went first. He granted a motion for summary judgment, finding that it was fair use to take books, digitize them, and train off of them. The fact that copies of books were digitally created during the training process, that too was fair use, but found that downloading books from what they called pirated sources or pirated data sets was not a fair use. And there's some nuance to that, and set a trial date of December of this year. And so the parties were off to the races. In Cadre, a few days later, the judge in that case granted Meta's motion for summary judgment, found that training an AI model is fair use, that an AI model is a transformative technology. You could arguably find no further or more transformative example, and insufficient evidence that there was market harm for the plaintiffs at issue in the case. The plaintiffs at issue in the case included Sarah Silverman and Ta-Nehisi Coates and other celebrated authors. And so you had slightly different viewpoints in these cases. There were some pretty key distinctions, including Judge Alsop finding that the source of the data set should matter, and Judge Chabria saying it doesn't. There's big news that you all read about in the last couple of weeks. The class was in the Anthropic case was certified, which meant it was going to be a class action case. That did not happen in the Meta case. There were emergency appeals in that case. Anthropic wanted to appeal the summary judgment ruling, the class certification ruling. And meanwhile, the judge was dead set on a December trial and still may be. And in the midst of it all, the parties went to mediation and announced that they'd settled the case in a proposed class settlement. News came out last week that the settlement was $1.5 billion. The estimated class of works was roughly 500,000 works. So it works out to about $3,000 per work. There's a lot of open questions as to how class members would be notified, how rights would be secured, and so on. And the parties are still working that out. So now what? Well, we're going to see how that plays out, and we're going to see how the other cases play out. There are cases right now dealing with outputs. I highlighted some of these early on. And so what's next? I anticipate, and we're seeing a flurry of activity as a result of these rulings, new litigation with new targets and new theories of liability, different ways of articulating damage. And I think that you're going to see some additional cases against intermediaries, maybe against the end users, and against the upstart Gen AI companies. So far, the cases have been against well-funded companies. I think that the plaintiffs' bar will start focusing on the smaller companies the second they get any small rounds of funding. So there's a very brief overview of what's going on. So transitioning to a subject that I think all of us can relate to, we're lawyers, how do we use AI in our practice? We're doing it. We'll talk about that in the Q&A. Well, what happens when attorneys misuse them? And so lawyers are getting called out in the press. One of my colleagues is tracking this. There are over 160 hallucination cases since June of 2023. You could see that it's on the upswing. There are model rules that govern us as attorneys, and we're not supposed to make false statements. Well, citing a false case, a non-existent case, non-existent articles is a problem. And so how does that manifest itself? You have cases involving lawyers making up cases using AI, fabricated quotes, made up exhibits, or erroneous quotes, and non-existent authorities. And there are a couple of websites here that I can share with you if you email me. There are people that are tracking these cases where people are getting sanctioned for misusing AI or at least accused of it. I'll talk briefly. How much time do I have? Okay. I'll just go through a couple of these.
Yeah, that's fine.
These are cases in which people use AI generated legal sites and got caught doing so. And the attorneys were chastised for them. And in one case, there was public reprimand and disqualification. And that's pretty harsh. In an Anthropic case involving a different plaintiffs group than the case I mentioned earlier, a very reputable firm submitted a declaration to support a statistic, and the footnote cited a non-existent article. And an associate had to submit a declaration from that law firm stating that she was actually given the right citation. There was a real article, but Claude AI formatted it and it turned that into a fictitious citation. And Judge Van Keulen of the Northern District expressed concern, did not sanction the attorney with any money, but did strike part of that declaration. And I think Judge Van Keulen is very reasonable. She's a former big law practitioner. I think she took it easy on the parties there. And there is example upon example. We're seeing it every week. And I'm happy to share this deck with everybody. But even as of last week, there's a very big class action against an online platform where there are 7 or 8 plaintiffs firms involved, including a couple reputable ones. And it turns out they were caught using AI not once, but several times. And so the firm on the other side has moved for significant sanctions. And in response, just last week, the firms blamed a contract attorney who then pled that her father was ill and dying, and she did turn to AI and she regretted her mistake. The problem is every law firm signed every brief that she allegedly helped with. And so the judge has issued an OSC in the Central District of California and is probably going to drop the hammer on somebody, if not everybody. So it's a serious issue.
Have you heard of cases where legal departments, in-house legal departments have been, they've been
No,
misused?
and I have not, but it's likely because in litigation, the in-house legal departments are hiring outside firms.
That's true.
And the outside firms are not going to blame their client.
That's true. Bobby has given us an update on the latest litigation and regulatory framework. I'd like to ask you two in-house, what is your approach to complying with evolving and varying AI regulations? Do you ask your outside firms to give you the latest and what you should be doing?
Yeah, so we have AI, sort of like an AI practice group as part of product, IP, and privacy. So that's how we had the function, and that ended up having sort of responsibility for AI. By the way, I've been at my company for 4 months. But and so that group, it works with external counsel to track the various regulations that are coming out. And then we also do try to give a periodic update to our board, I would say once every 6 months, on evolving regulations, our own AI governance within the company. But for an in-house department of our size, I would say we have about 45 people total, including attorneys and everybody else. Just keeping track of that, we definitely need to work with an external firm to help us manage and keep track of things.
So what we have been doing is we have a small public affairs group, and so they are tracking what's happening globally. We leverage a lot, trade associations. So like the U.S. Chamber of Commerce, I'm on the board there. We also are a member of BSA, and so they've been very helpful. We also have there's a lot of AI, tied specifically to privacy issues or employment issues. And so our employment and privacy teams will kind of separately follow up, but that's mainly coordinated through our public affairs group. Beyond just tracking what's happening, we decided that we were going to have, we had developed a large language model 18 months or so ago. I mean, we're no longer really in that business, but because of that, we stood up. It's done through the product counsel team, but we did stand up an AI compliance program. It's actually very much like copied off of what a lot of companies were doing with respect to GDPR. And so the EU AI Act is what we're using as kind of the umbrella framework for what we're tracking. And then other AI legislation, as those are becoming effective, we will roll that under kind of the umbrella framework that we've had. And so that has been tracked. Like one of the product counsel leads that. They also have a project manager who's assisting them, just tracking all of the requirements. And so from a reporting perspective, I think, similar to what Rashmi described, we aren't reporting out to the board, we're reporting out to the audit committee. So we will have sessions where it's a regulatory update, and then separately we'll have a policy update for them. And that happens about once every 6 months.
I'd love to sort of get to utilization of AI tools in your in-house groups as well as the law firm. Bobby, what are your top priorities when it comes to your legal team's utilization of AI tools, and how do you currently use them? And what are the best tools, from the law firm perspective for you?
Cooley has always been known as an innovative firm. We're a tech-forward firm, so it is expected that we leverage technology, and AI is an exception. I think a lot of our clients are expecting us to use AI and demanding it to encourage productivity, efficiency, et cetera. So a priority for me is making sure we're using it responsibly and effectively. Recently, and I'm on the AI steering committee for the firm, we've been using a tool called Harvey AI. I don't know if anybody, by show of hands, anybody using it. A number of us have access to it. I think my colleague Judd does. We are experimenting with it. We're reporting back. We're on a group chat that talks about what it does well and what it doesn't do well. I can tell you as a litigator, it is a game changer. And I'm going to give a couple of examples for those in the audience. And I would encourage you to play with it yourself and try it. I've heard great stories from my transactional partners as well and how they use it. But I was preparing for a really big oral argument. And oftentimes when you do mock arguments, you recruit your colleagues to ask questions and read all the papers. And so I did that. And Judd was one of the mock judges. But one of my colleagues had the idea to feed all of our papers, including all the declarations, into Harvey and said, I want you to act like a judge in this Northern District of California, and I'm going to give you all the papers. I want you to read it, and then I want you to come up with the most challenging questions you would ask the plaintiff and the defendant. And it did it. Some of the questions were weak, weren't helpful. Some of the questions were the equivalent of a junior partner who's savvy in that area, picking up a nuance. And it was really impressive. And then we asked it to suggest answers to those questions. And it did. And some of the answers were fantastic. What blew me away is it then cited to and hyperlinked to our papers. So the Ghajar Declaration, Exhibit C, for a quote from a deposition. And so that kind of exercise would have taken a junior associate dozens of hours if they would be able to do it. So I think that's an effective use of it. We're using it and we're experimenting with its use for discovery. So let's say you're doing written discovery in a case, you have a good sample from 5-6 cases, you feed it the complaint, the answer, maybe some public articles on the case, and say, use these templates and format a set of discovery that would be appropriate to ask this company. And it'll come up with some stuff that's useful and some stuff that's not, but it costs you almost nothing. So myself and my colleagues are experimenting with it to try to get the most out of it.
John, what are you guys doing?
It's interesting. I mean, we also are, involved in some of the copyright litigation. I can tell you we've been very closely aligned with our outside counsel on where they're going to use AI and where they're not. And we were very familiar with that because we did not want to be in a situation where there was a hallucination happening with respect to anything submitted for us. So anyways, I'm glad that Bobby is using it, but we have been a little bit more, less at the forefront of that. And I think that's a little bit my my methodology, like even in-house, where, I mean, there's a bunch of things that are low-hanging fruit, but even being at a data and AI company, I have taken sort of like a two-pronged approach. I mean, the first is, with respect to the low-hanging fruit, I think that is like easy, where, I mean, things that are like a chat bot, I mean, we have rolled those things out, and, and we did it first with things that were super easy, like birthdays and like anniversaries at the company. So there's a little chat bot that handles all of that now. Our assistants no longer have to pay any attention to that. I mean, there's a number of things across the company where, there's a, question that could be asked, and, somebody, a certain function, whether that's employment or whether that's our privacy team, all of those are being explored, and some of them have been rolled out. But, and the other thing that we've done is we have a business intelligence product. It's called AIBI. And so we have migrated all of our dashboards onto our internal product. So those, I think, are the kind of low-hanging fruit items that were easy for us to do. But the other prong of it is I'm actually not in a lot of rush to roll out a bunch of AI tools. I do, think that even if I were to become like maximally productive and efficient in AI use, I mean, I have a team of about 75 people. And so that's not going to help that much within the company. We have been much more focused across our company and like, what are the use cases for go-to-market or R&D, since they comprise more than like the majority of our company. And so productivity gains there are going to be so much more impactful for the company. And so I've let those functions kind of take the lead. The other areas that we've used it is just for research, but our team just doesn't do a lot of research. So yes, we have access to GPT Enterprise and Perplexity, Gemini, et cetera. But that's such a small part of our work that I really have spent a lot of time working with our legal ops team I mean, the hard part of AI is actually making sure that your data is super clean. And so we have been spending a lot of time doing that with the hope that when the tool comes around that is really impactful for us, that we'll have the data that's clean and we'll be able to create pipelines really easily then. And so that has been what I prioritize rather than like seeing what else is out there, because there've been a lot of attorneys in my group who've been super excited by it, but it's like, let's calm down. Let's be super organized about this. And I'll give one last example that, I mean, we were all really excited about, like redlining tools. The biggest part of my legal function is my commercial team. They comprise about 35–40% of the team. And so I thought, if that's one area within legal that I'm going to prioritize, that will be it. They'll have the most impact. And a lot of the tools out there are just not ready, enterprise ready from a security perspective. And so they've gotten excited, but then it can't get past security review. And so that's why it's just another reason where I'm not going to implement AI if it's going to be problematic from a security perspective. So we have not been as fast at rolling things out. We do want to take a little bit more of a methodical approach.
Rashmi, do you have tools that you've been using, and what have you got? What's your approach for your team?
Yeah, so we do see a lot. So we do have an initiative sort of across the company to utilize AI where it makes sense. So everybody's incented to do that. I find other groups are using it, marketing in particular, for first rounds of generation of content, which then gets vetted and reviewed by somebody in the marketing department. So other departments are looking at it. Support, our customer success organization, they really wanted to use a functionality to summarize calls with customers, because the customer would be notified that, with the notice that it's being used, consent to it. But what we did is we also put some controls around that, like retention periods for how long the summary would be retained. It would have to be reviewed by somebody for accuracy, whoever actually was the person who conducted the call and initiated the AI summary of it. But so there are tools that are helpful to people in other parts of the organization. And we too, in the legal department, have this goal, along with the rest of the company, to look at AI. we're probably a little bit behind the rest of the company as well, probably a little bit conservative by nature. Right, this currently what we have is we have a sort of a proof of concept pending. So we have led by our commercial team, looking at 3 different tools to evaluate a couple of things. So what are their capabilities to, if we give them a clause and say, can you approve upon it? Let's say it's a warranty clause, indemnity clause, just gonna see what they can do with it. I don't have any results yet. The other case would be just that initial red line. And so we have a form NDA. So we're going to say, okay, how does it do learning our NDA versus other NDAs? And I would envision that even if we were to find there's some success, we would still have somebody look at the resulting red line, go through it before it then goes out to the other side, whether it's a supplier or a customer. So I do think there's some, if we get, and since we're just at a proof of concept talking to these vendors, we haven't gone through the security review, as you mentioned, right? So I don't know if any of these tools would make it through that, and they would have to go through something like that before we were to actually adopt it. But I am hopeful that you could get a decent first pass, and that could save some time, right, for the attorney doing that, because NDAs all take a long time, right? Everybody says use my template, use my, there's a battle of the templates. We always say use ours. And anyway, so if we found a way that we could improve our efficiency on that, that would be helpful. And then leverage that to go into other agreements as well, like our master customer agreement or master supplier agreement, things like that. So that would be the path we would be looking to take in the legal department.
John, are you specifically hiring for AI expertise on your legal teams?
So for our product counsels and our privacy counsel, that is something that I think is a plus. But in terms of, and I think like even for other areas of the legal team, it is a plus. But I feel as though there's so little, kind of candidate pipeline that actually has that expertise. And so I would rather prioritize somebody who is super smart, who wants to learn it, and then we can come in and we can train them, right? So I would rather kind of have that than have somebody who, has a bunch of AI experience, but, they kind of don't meet the caliber of the person who we need.
Yeah. Would you, like, how would you advise an in-house counsel who's who's interested in AI space, who wants to work for Databricks? Like, how do they get themselves up to date? And
I think showing an interest in AI is super important. And, and there's so many resources out there. So the first thing is like just keeping up on like relevant topics, impacting AI. Bobby's, presentation just now, for instance. And so there's so much CLE that is geared towards like, providing an update in AI. So I'd really encourage folks to, like attend those sessions and kind of get up to speed and track what's happening. The other thing is, just go out there and use it. So become proficient with it. Databricks, for instance, offers a free edition. Everybody can get a free account. And so, sign up for an account and, start using and, see how it goes from there, or use Harvey or but otherwise become proficient with the many AI tools that are out there. But showing an interest, I think, is like really important.
Yeah. Bobby, how are you tracking your associates and other partners' use of AI, and how is Cooley managing that without, it going sort of out of control and not within your purview?
The use of AI within the firm is very much regulated for a lot of the reasons given. And so after a big push and pull with the firm, we finally got approval on a limited basis to use Harvey. That's to say that associates and partners are not supposed to be using AI unless it's an approved AI tool and they are approved to use it and they go through training. And we are on the litigation teams, we're making it very clear to whoever's authorized to use it that you cannot rely on it and a human's always got to review it and proof it. The same way for those litigators in the audience, when you finish a brief, even if you're the one who read the cases, you have somebody site check it. There's a paralegal who site checks it. 12 hours of time. You think my citations are great. Why do I need it? You do it anyways. Well, same thing with any AI related work. On the corporate side, for my partners who are using it, I understand that, like you were suggesting, Rashmi, like if you use the redlining tool, you're still going through every single character. So it's saving some time in terms of maybe the processing, but a human is still reviewing it. And so it's not carte blanche and far from it. And I don't know when it will be, but it's limited use. I can't tell you what people are using or doing outside of the firm. Our firm, if you were to try to use ChatGPT and upload something to it, the firm has a blocker that pops up and says, firm governance says you can't use this, click here to acknowledge.
Do you have, Rashmi, do you guys have something like that?
I just learned that we have something to prevent people from using certain AI tools, like an actual software that's got blocker as well. But that's recently implemented. Yeah.
Oh, interesting.
Yeah.
Okay, well, I'll have to check my company. No, we do have sanctioned products that we can use, and hopefully that will work out for us. What is your personal outlook on the impact of AI on lawyers and on the legal industry? I mean, there seems to be a little bit of concern about AI replacing some of the junior folks, both, at the lower levels of, associates as well as counsel level in terms of the contracts, initial contracts review, drafting, all of that. What's your outlook? Where do you think we're going?
I'm an optimist, so I see it as reducing some of that drudge work that the junior associate or ends up doing. Like, I remember getting like a box of documents, and it's like, okay, we want to know whether it was a company that mostly had distribution agreements and resale agreements, and like, could they be terminated because the company was going to be acquired, and was there any assignment provisions? And after practicing for a while, it's like most distribution and reseller contracts, if there isn't an agreement to supply or something like that, usually can be terminated on 30 days notice because you just place orders if you wanted to. So I didn't know that back then when I was reviewing all of these. But can you imagine just having a tool go through and say, look to see what are the termination provisions for this agreement, for all these agreements, and then can they be assigned? And since they can be terminated within 30 days for the most part, it didn't matter if they could be assigned, right? Because somebody could just terminate it if they wanted to, right? So I don't know how, it wasn't exciting work for me. And so if that's what's going away, of course, human would have to review and, look at the output. I don't see that as a significant downside. Maybe it does require less people to spend time doing that, but then you could start at some higher level of, okay, now that we know this about the agreements, what's relevant in this transaction to the acquiring company, right? And start at that level as opposed to doing that kind of work. So it is a little bit, we've had various, the internet came around, right? So I've been working for a while, and all the other things come along, right? And you think, well, it's going to change things. Yes, it will. But I think this one, maybe just because as you look at the capability when you interact with chat functionality, its ability to spit out answers and things like that, you think that maybe this one's going to be worse. But I'm going to remain optimistic on that and view it as eliminating some of the drudge work that we all did when we started in our careers.
What do you think?
Yeah,
Pam?
I absolutely agree with Rashmi. I mean, I also am an optimist. I don't think that lawyers are getting replaced anytime soon, if ever. I actually think it's in the latter camp of if ever. I mean, I do think it's going to increase our efficiency and our productivity. So that I definitely agree with. There are like It's interesting. I mean, I had an legal all hands earlier this week, and this exact question came up. And it was somebody on the commercial team who said, "Are you going to do away with the commercial team?" And a part of my response was, I mean, what differentiates legal from other functions is also that, I mean, our work has to be accurate, right? I mean, and there's so much hallucination that happens with respect to AI that, I mean, it's not good enough actually that something is 65% accurate, right? I mean, our work has to be accurate. And so that's what gives me the optimism that we aren't going to get replaced because of that need for accuracy. I mean, even if we're being more productive and we're being more efficient, I just don't see like a human not being in the loop because of that need for accuracy.
My nephew's at USC, and he was asking me thoughts on law school, whether he should consider law school, because he's thinking, oh my gosh, are the law firms going to be hiring? Are there going to be fewer spots? What do you say, Bobby, to him?
I don't know. You took the words out of my mouth when you said you're optimistic. I think it's an evolution in legal tools. I've been practicing long enough that when I was in law school, we were reviewing books and the indexes on legal reporters, and that was the way we did research. And Lexis and Westlaw existed, but a lot of the judges, including the one I worked with, didn't allow us to. He didn't trust the electronic databases. And then I think at the time the concern was, well, everyone's manually reviewing everything, banker boxes full of documents. If you go to digital review and you can do word searches, what are first and second year associates going to do? And then you had contract reviewers. Well, what are first and second year attorneys going to do? Oh, you have digital review and outsource to another country. What are first and second year associates going to do? Then you had AI assisted review of documents and litigation. First and year associates have plenty of things to do. I think they'll get better at it. There's zero doubt in my mind that it will promote productivity and efficiency. And I've already seen a glimpse of it. And it's just a matter of time. And I think that, like the software programming space, I think it will have a profound impact on that space. But the average software programmer can become a very good one. A single software programmer can program for 10, as these are the benchmarks I've heard about. I don't know that translates directly into our field, but I do think that a good associate with a sharp legal mind, and that's important, we need to develop that, will be more productive, more effective, and can do better, high quality work, and maybe leave the dredge work to AI.
I'll add a little bit on the recruiting front, because that's an area that people think, oh, well, will AI replace recruiters, and could we sort of have systems in place to look at resumes and do video interviews that are and I laugh because I realize that is one of the things that is probably that's the most special about our job, is really just assessing people, right? And I just don't think AI is even close to that.
I'm going to say in my prior company, in this company, when HR came to us with, oh, we want to use AI to screen resumes, that was one where I gave pause. It's like, this is not an area where we can make mistakes, because there was something where I think the training was based on a bunch of resumes that mapped to a certain demographic or person, and a male person. And then so it just got trained off of that and was looking for that in the resume. So even to summarize, I think that's an area where you just really, you're one, you may get into trouble because it's not following the company's hiring policy, which is to, vet and look for the best candidate, because it's screening out people based on factors we wouldn't normally use to screen them. So they do say that, reviewing a lot of resumes takes a lot of work, but there is some, I think, just initially you're looking for hits on certain words. So we know that, so we're using that, but going the second level of having AI, I was held the line there on that. I said, I don't think it's far enough along to be able to be reliable, and we're risking not treating people appropriately because of it. So that's been my view on it for resume review. People deserve the dignity of having a person review and then follow up with them.
Yeah, and the reason you guys pay us the big bucks is because even some of your internal recruiters aren't good at reading legal resumes,
Right,
right?
exactly. Yeah.
Having lawyers do it, having folks who've been in that business really give people a fair shake. I think that's something that is the misuse and the bias is something
Yes, the
that's
bias
a
is something
big
to really watch out
issue
for.
with systems. Yeah. If you can share publicly anything interesting that your companies, I know Tom probably has some fun stuff that, Databricks is working on.
Yep, I think like the thing that I'm most excited about is we recently released a product called Agent Bricks. And so that's a product that helps companies develop and optimize agents for common use cases. So if you want to like extract information, or if you want to create your own LLM, or have a knowledge assistant, then using this product like helps you create that agent faster. And then after you've created it, optimize it. So that's the product that I think, and that's gotten a lot of traction. We just released it a couple of months ago, and it's gotten a lot of traction. So I'm excited about that. But I mentioned earlier our free edition, product, and so that was also released a couple of months ago. I just, encourage people to go on our website and download it and have some fun.
Rashmi.
I'm going to say agents is the next wave. So you kind of had sort of the chat functionality, chat GPT. And so in our products, we have this Claire AI. And so it gave you natural language capability. So you didn't need to know so much about, how to run queries or to even like coding to collect the data, to answer the question you wanted, because we were a data management platform. So you actually just use natural language. So that means you don't need as much technical expertise, and that other people within the company besides people in the data science organization could do that. So the next step is now agents, and they're going to be automating sort of workflows. And I think a lot of companies, so we're not unique in that, obviously, Databricks has them as well. So that we announced ours at our last user conference in May.
That's exciting. What are you? Anything?
We're not rolling out any new products.
What's going on with you guys?
I think we debated, it's a little bit of a tangent. We debated whether we were going to launch an AI group, like other firms did, to announce like their arrival in AI. And we had a really robust conversation internally. And as it turns out, Cooley's been doing AI work for decades. It just wasn't called Gen AI. It was machine learning. It was learning before that. And so we didn't want to act like it's something new. So AI now is part of every one of our practices. We have a task force, and I'm really proud that if there is an AI issue, I have somebody within the firm that I can turn to, whether it's terms of service, whether it's a licensing deal. Litigation is my sweet spot, along with Judd. We counsel companies on letters they're getting from publishers, demand letters from random plaintiffs. So there hasn't been an issue in the AI ecosystem that my colleagues have not been able to field effectively. And we recently were called in like 3 days notice to rewrite an AI handbook for a 7,000 employee company. And I turned to several people in Europe and in the United States, and we were able to turn it around in a few days, and this company adopted it. So it was really impressive to see the speed with which they could move on something like that.
Well, that's great. I'm sure you guys have some questions for our panelists. I'd love to get going. Go ahead.
Great that you mentioned. My name is Rachel Zardo. I'm in Health Counsel now for Technology. I was really hoping someone would raise writing a handbook for internal purposes, because that's kind of what I've been tasked with at my company. And I have like the big picture kind of elements to it, but it's interesting. I'm the legal person, and I'm working with business people and tech people, and we're all coming together trying to come up with something that is kind of a roadmap that, increases, efficiency in our company. But obviously my role is to identify the risks and, best practices from a legal perspective. And I was hoping you guys, kind of in your experience, or Bobby from your handbook, could identify kind of the big buckets of areas where I could focus.
I'll give a I'll save you the hassle. I'll give a very brief answer for the benefit potentially of the audience. But I'll do you one better, that email me and I will send you one, not the handbook I did for the client, but we have an AI policy that we have helped clients with. It's like almost a generic template that's really robust, and then you tailor it to your company's needs. And as it has evolved, we send the updates to clients. And so a lot of clients have taken that and updated. So that'll help you rest easier. Judd and I have worked on this for a lot of clients, and I think there are a lot of gating issues. One is which tool to use. You want to green light certain ones, and you want to block many others. And so you need to determine by interviewing your engineers, marketing folks, like what tools are you going to even permit and why? And early on, there were fly-by-night AI companies not based in the United States that had very extensive terms of use, which would unwittingly allow them to have IP access to anything that you upload. Okay, so you can't have that. You have to have some trust and diligence in the product. So who wants to use it? Why? Which tools and platforms have you done diligence on them? Are they public companies, et cetera? And then encouraging people to understand the repercussions if they go outside of the policy, because you know how easy it is for any of us to download an app on our phone. I am aware from interviewing clients that a lot of employees have been caught using it on their personal devices, and they're simply sending it. And so helping them understand the repercussions. And then finally, I'd be remiss if I didn't mention this from an IP perspective. I didn't get to it because we were covering two parts in my presentation, but the law is still, with an exception, that if AI creates something that's creative and valuable, a human doesn't own it. Now, the exception is where the human iterates, selects a range, organizes, but if you create a beautiful graphic, a novel, something that's of interest to your company in marketing, and a competitor copies it, you create it with AI, you don't have any copyright ownership in that work, most likely. That's the current law. And so teaching your creative folks, your marketing folks, that there are limits. And then finally, we've given use case scenarios that are likely safe. Okay, if it's employee handbook where you're compiling some regulations and a human will review it, it'll help you do that. If it's internal marketing and so on. So those are things that the policies tend to touch. Oop.
Could I ask one more on how you think about coding? Because a lot of the startups, they really want to use like Cursor and other products to help them code. I get worried about IP infringement and all this.
You have, do either of you want to answer this? I don't want to.
Go ahead,
Okay.
Bobby.
Okay.
We'll supplement.
Okay. Well, you will always have a risk of infringement, whether you have AI do it or whether you ask somebody you don't know to do it. Although you can quiz the person that you hired, where did you come up with this? How long did it take? And so on. You can't do the same with AI. The other issue we've seen is a lot of the AI code is open source. And so you have to give attribution to certain open source rules you have to be aware of. And so once you use AI to create code, you lose the ability to trace it back to open source code. And so you could run into issues there. What we've generally advised is that using AI to create software code is okay if it's not an important part of the business. But if it's critical software for the company, there's definitely risk.
Just follow up on the ownership issues. Have you seen developments on patents, just in terms of, and I understand a lot of the cases are
Right.
open source, but I know there were some questions about mentorship.
Do either of you have an answer?
I'm not a patent expert.
Okay.
Neither am I. I don't think we've had any like AI generated materials that we wanted to patent at the company. Yeah.
So the last I checked was that the patent office was more permissive than the copyright office in terms of allowing human ownership of AI assisted patents. There was a regulation passed that spelled out what you need to do and how you can achieve it. I haven't seen litigation around it, and I haven't read office actions at the U.S. Patent Trademark Office where people have succeeded and failed, but it's definitely more permissive. Put another way, you can get a patent on something that was created with the assistance of AI in Judd, do you want to add to that?
Just put a little more color on that. The way that the USPTO approaches protectability for patentable inventions, it's the same standard as co-inventorship, which is very different from the way that the Copyright Office approaches authorship. For authorship, it's not the same way that you would approach joint authorship. It's exclusively whether the AI user has imbued the work with sufficient human creativity to be regarded as the sole author, whereas for patentability, it could be sufficient that the human was involved in the way that a joint inventor.
What about, sorry, questions?
No.
What about any divergence in jurisdictions, European versus?
That
Yeah.
There are quite a few general counsels in here, as well as high-level in-house counsel. What are you guys using in-house that you might want to share with us? Anyone have like a great tool that they're using that they love?
I'm not using anything yet, but I've looked at a handful of our GCAI.
Mhm.
A lot of people say,
Yeah, I know the
Julia was
founder.
supposed to be
Yeah.
here.
yeah,
She,
I mean, everybody probably knows it by now.
Yeah,
Probably
yeah.
reached out to everybody and for the GCs in the room, you know, many of us are L suite members, and so we got to chill. Not a problem. I was curious, Trump, you mentioned that some of the kind of legal productivity software that you looked at didn't pass your security screening. And I want to understand, you know, kind of where it fell down. I mean, the thing that I'm always concerned with is, hey, you know, we're uploading documents or a legal team playbook or something like that into one of these services, and then they're you know, using this to train the model, which many of them are saying, you know, we're not doing that. This is confidential to you. This doesn't go anywhere else. But curious as to, you know, kind of the scrutiny that you guys have put on it, and kind of where these products have fallen down.
I mean, it was my legal ops team who took the lead, and so I'm not exactly sure what, you know, where it fell down, but I mean, we actually couldn't even do a POC. I mean, the demo looked super good. And so to move on to the POC, and although that's it for this POC, I mean, we really needed to see what it was going to do. We were going to upload our playbook. And so so it was going to be in production, right? And so because of, you know, the fact that it was going to be in production, we weren't going to use dummy data. That's what triggered the more enhanced security review. But they actually came back with, these are the 5 things that you're going to need to fix in order for us to be able to use it. And so those vendors are working on it. I mean, we did give them that feedback, but I mean, at the end of the day, it just was not, you know, enterprise ready.
Do you think they'll get there?
They've, you know, committed to it. It's been more than a quarter since we gave that feedback. Startups, of course, are, I mean, they've got a bunch of other priorities, right? So
You guys are a big customer.
potentially, exactly.
Anything else?
I'm kind of in the same boat. We're just sampling and I'm very interested in using, I think the use cases I'm most targeting are the intakes. Because as an in-house legal team, you get hit up all over the place from various clients, and having one centralized intake that can help you funnel it, give responses back similar to a bot to respond to easy questions. I think that seems very enticing, and then giving you data that you can share with the management to show this is where our team is having impact. I think that seems really cool. I'd love it if the redlining stuff.
The one
works.
thing that I would
Oh.
just, I mean, you know, we have like, you know, we use Fresh Service generally for intake with within legal, but we have found that, I mean, we want to like meet our internal stakeholders where they're at. And so for R&D, for instance, they're going to use Jira. And so whatever tool we're going to bring in, we're not going to say, oh, well, you're going to use this tool for everyone and then take them out of Jira. So that's like one other thing that we have, you know, thought about, that it really can't be a one size fits all, you know, approach for all of our stakeholders, because we want to make sure it's easy for them to reach out to legal.
And then obviously the redlining would be amazing if it gets to the point where we can rely on it. I think that would save a lot of time.
With a show of hands, do your companies have an AI policy in place? Oh, wait, this is a very
Yeah.
advanced group.
Mine will after Bobby's.
Yes.
Yeah. I have a draft, but I have to update it still.
I'm happy to. And everybody, I mean,
He's
if I
taking
can,
new clients.
everybody should, and we're happy to help, and everybody should have a policy, because what I found, and when I've done these in-house, there is a disparate view among the staff over whether it's taboo or whether it's something they're going to use every minute of every day, and it needs to be moderated.
All right.
I
Yeah.
actually have a quick question for Bobby. Can I ask you, how you track your partners and associates using AI? You mentioned a couple of things that they have to train and committed. One thing I was kind of expecting to hear but didn't was whether an individual client has authorized that.
Sure.
Do you have individual conversations with clients? Like, how does that work?
So it's another interesting question and issue is some new engagement letters with clients. So we have our Cooley engagement letter, but sometimes clients have theirs, address AI. Some of them want AI used, you have to disclose it, and some of them prohibit it. So earlier when I mentioned feeding documents into Harvey, which is a closed box, highly regulated, super secure, super vetted, we're still not allowed to put in like internal memos we've done for clients. It's like whatever's on the public docket. So we're having conversations with clients about whether we can use AI and what materials we can use. So it's publicly available materials, there should be no issue. If it's a client memo, we won't use it unless the client authorizes us to.
I guess what's the concern there? Is it reach or like not trusting the technology or not wanting to, I don't know, from a billing perspective, I guess, like the investment in outside counsel?
I'd have to ask, I mean, if you, I don't know why, if maybe the client doesn't want to undertake the burden of understanding what tools the law firm is using or a vendor is using. Maybe they trust the law firm, but not the vendor, and they want one size fits all. So they don't want the vendor/law firm using a tool that they have not vetted. And maybe they're concerned over security risks. Or I think one of you mentioned, is it really training off of the work and revealing it to others? Because your worst case scenarios, you do like this internal memo on privilege, and then the AI tool you're using learns from it, and then somebody else somewhere else queries it, and then it spits out information from that memo. That cannot happen. So I'd have to ask the in-house counsel.
I mean, I'm worried about privilege issues. I also am worried about confidentiality. I mean, I came across a law firm that actually had a provision that they were going to train on our information, and we did not hire that law firm.
Oh.
I mean, it was something that when we pushed back, and I thought this is going to be easy, we'll push back and they'll take the provision out, and they were steadfast that they were not going to. They came back 6 months later and said they've heard enough feedback from clients that they have now taken it out. But it was like an interesting thing. We have still opted not to use them, but I thought it was a super interesting take. I mean, we used 30 plus law firms, and I had not seen that approach with any other firm.
Interesting.
Yeah.
Do you vet your firms, and ask them about their AI use, what they use,
I don't, outside the litigation context, that's the area where, because there's just been so many of those cases around hallucination. So that is the one area.
So law firms go through the general supplier vendor process, and in that process, we do ask if they use AI and how it's used, and definitely don't want our data used for training either. So yeah, that's
Got
it.
Yeah, no,
Nope.
that's really
Yeah.
important, right? Like you need to know what they're using and what they're training their associates on. All right,
Do you have any situations where there's a delta between what a particular client will allow and what's in the actual AI policy? It probably sits less with the law firms and more companies, where you have 50 or 60% of clients who say, yes, you can use AI for XYZ, but then you have other clients come in with agreements who have ironclad, thou shalt not in any way touch, think about, do anything with AI with respect to services and products providers? And how do you address that in policy, and then from an operational perspective, how do you advise clients to personally?
Haven't advised clients on that issue. On the litigations I manage, I know what the clients have allowed us to do and what they prohibit. I don't know that the policy addresses that, other than maybe reminding folks that different clients have different guidelines. It's an interesting question, and at some point, what I know from a client, I can't be the bottleneck or the person who decides it, and so I think that makes it challenging, which is maybe one of the reasons why, for now, the firm has only allowed a limited number of people to use AI. I mean, it's a very small number. We're a 1,600 person law firm, and it's a fraction of that.
Oh, really?
So I think it's in part to avoid that situation, because the people they're allowing to use it go through training. I'm obviously heavily involved in AI, so I understand the subject matter. I also understand the risks, and I understand our clients. But I think as you scale it out, I think that's going to be a real risk. How do you police that?
Are we ready for some drinks? I think it's in the next room. I don't know if they're opening it up.
I think
or
we just
have
go
to walk
around, yeah.
around. Yeah. But thank you, everyone. This has been a really insightful discussion. I appreciate our panelists. And Bobby, you and I will do this again with
Always fun.
new updates every time. But thank you so much for joining us, and come hang out with us and chat some more.
Well, thank you, Tim.